Yo, it's JP. I'm going to talk today about racism and specifically about so-called reverse racism. So let's start here, okay? Every week, at least 5 or 6 people contact the firm and they say, well, I'm dealing with reverse racism. I got a case of I'm being the victim of reverse racism, okay? Well, folks, there is no such thing as reverse racism. Reverse racism does not exist. Take that word out of your vocabulary. Take that phrase out of your vocabulary. The notion of reverse racism is one of the dumbest, most nonsensical things I have ever heard because it completely misunderstands the concept of racism. Racism entails that someone has hatred or hostility or animus directed at a person because of their race or skin color. It doesn't require any reverse. Racism is racism. Full stop. Say it with me. Racism is racism is racism. There is no reverse. Okay, now that we've addressed that, let's move into the types of inquiries people make, all right? When folks show up and they claim that they have been the victim of reverse racism and they use that specific term, more often than not, these are a certain type of individuals, okay? Folks who throw around the term reverse racism, more often than not, I regard these people with a great deal of suspicion and skepticism. These tend to be folks who were hanging out down at the Piggly Wiggly and ranting and raving about how they want our country back. Okay, they took our jobs. All these Mexicans, right? That's who's out there complaining about reverse racism. But be that as it may, I have one time seen a case that fits into that specific category. And again, it's not reverse racism, it's racism. All right. One case out of thousands of cases that have come in the door, come across my desk, involved racism against a white person, but it wasn't just racism by itself. It also implicated sex. The specific situation involved a professor at a university in a certain department, and the powers that be at the university and at the top of the department were basically getting rid of anybody who was a straight white male and replacing them with women, minorities, people who were gay, transgendered, etc. Right? So it wasn't just that the person was white. It was really a combination of factors. And I looked into it, and sure enough, it did strike me that this man, this straight white male, was discriminated against on the basis of being a straight white male. Okay, and now this is going to blow your mind. Okay, right now, we got people watching this video, right? Probably sitting over there at the Piggly Wiggly talking about immigrants who are invading the country and taking our jobs. Probably like, my God, this guy's talking my language here, talking about reverse racism. Yeah, that's me. He's right. Well, there is a point to this, folks. Okay, there is a point to this, right? In America of the past, 10, 15 years, it has kind of been open season on men at large and bashing men, tearing men down. Like that has been a significant aspect of society over the past 10 to 15 years. And, straight white men are kind of in the doghouse of society at the moment. But guess who else has been in the doghouse forever is black people. Okay, right? See what I did there? Okay, two things which you think are in conflict can both be true at the same time, right? So we got the Donald Trump flag waving MAGA folks over here talking about reverse racism. We got the guy at the Piggly Wiggly saying, my God, he's talking my language. I'm a straight white man and I'm being trampled upon and I'm being looked down on and bashed by everybody in society. Yeah, that is true. That is true. Now, like you had the run of it for, 400 years, okay, until maybe like the last 20 years or so, but like over the past 20 years, like you have taken a beating. But black folks have taken a beating this whole time, okay? And it's always been, right? Black folks have always been like, kicked around by American society, because when I look at the numbers, when I look at the statistics, the analytics in terms of the types of cases that come in involving racism, the vast majority of the cases we see involving racism at large, whether it's in the employment context, so it's employment discrimination, or it's in the housing context or public accommodations or retail, right? Whatever it is, okay? The vast majority of the cases I see involving racism involve racism against black folks, okay? And then second to racism against black folks is the racism I see against Hispanic folks. And in the cases involving racism against Hispanic folks, I see a lot of racism directed specifically against Mexicans. Okay, I don't see very many cases involving racism against white folks, but it does happen. Okay, it does happen. I just gave you an example from the case files in terms of a case where a straight white male was discriminated against. And there, I don't think it was solely on account of his race. I think it was more on account of, all of those different boxes being checked and the university wanting to check the other diversity boxes. And I'm on the record in terms of my, position on DEI and the whole nine. Okay. So where do we go from here? All right. Where do we go from here? Right. Well, there is no reverse racism. You know that now. Racism is racism. And so if you are being discriminated against, singled out, treated differently in any of these contexts, okay, because of your race, then you have to consider what legal claims are at your disposal. And in the employment context, you have Title VII, but as I've said before, Title VII is a paper tiger. And the reason why Title VII is a paper tiger is because there are damages caps. There are damages caps that have not been updated since 1991. And so there's no stick there, okay? There's no real leverage. The best vehicle for pursuing race discrimination claims is 42 USC 1981, 42 United States Code 1981. This is also known as the Civil Rights Act of 1866. Why is 42 USC 1981 the best vehicle for pursuing race discrimination claims? Okay, I'll tell you why. Number one, there is no administrative process. If you look at Title VII, and then you look at certain situations involving housing discrimination, there are many other arenas where you have to go through an administrative process. You have to file a charge or a grievance or some sort of notice with an administrative agency, whether federal or state or both. They do an investigation, and then only after you go through that process do you have the right to file a lawsuit. 1981 works differently, okay? Under 42 USC 1981, there is no administrative process. You're not required to go through an administrative process. You can just go right to court and file your own lawsuit. That's one. Number two, there are no limits on compensatory damages. So if you have a particularly egregious case, then you can theoretically get a very substantial compensatory damage award for things like humiliation, embarrassment, loss of dignity, emotional distress, etc., etc. That said, courts are fairly activist, especially in certain parts of the country. Courts are fairly activist about reducing compensatory damage awards. They don't want to see plaintiffs in these types of cases get big compensatory damages awards. But the saving grace is that 42 USC 1981 also permits unlimited punitive damages. And that is a huge point of departure from something like Title VII, where even for the biggest companies in America, the biggest companies in the world, the total bucket of compensatory or punitive damages available to a plaintiff in a discrimination case is $300,000. So they can get lost wages, lost economics, lost income, etc. But compensatory punitive, you're capped hard at $300,000 under Title VII. As opposed to 42 USC 1981, There's no cap on either compensatory or punitive, but the money ball is the punitive, because while courts might reduce a compensatory verdict or a compensatory award, okay, you get a big compensatory award, you get $1 million in compensatory damages. There are plenty of courts that are going to say, well, we think this is an awful lot of money. We don't think your emotional distress was that significant, and so we're going to reduce this to, 100,000, 200,000, what have you. And they might do that, okay? Some will let it stand. Some will let it stand. I've seen that recently, but there are plenty of them that will reduce it, okay? But even if it gets reduced, we're talking about your compensatory award here, okay? Even if the compensatory award gets reduced, the punitive bucket is going to stand and be reduced at most to 9 or 10 to 1 ratio, okay? And that's because we have a Supreme Court line of cases, State Farm, et cetera, where the Supreme Court has held that the ratio between punitive damages and compensatory damages, right? You're looking at what you get on punitives versus what you get in compensatories. Basically, that ratio is not allowed to go beyond the outer limit of, say, 10 to 1, right? 9 to 1 or 10 to 1. And so what's that mean in practical terms? Well, if you get a compensatory award, okay, and the court reduces it to $100,000, then the punitive damages award should stand at $900,000 or $1 million, because courts are far less inclined to reduce a punitive award than they are to reduce a compensatory award. And I mean, provided they reduce it to the State Farm cap, right? Courts will routinely reduce a punitives award down to 9 or 10 to 1, but they're not inclined to reduce it below that. And here's the reason why, okay? Although the court, I say it's activist, okay, but many other people will say, no, it's just the court's discretion, right? Yeah, courts have discretion when it comes to compensatory damages awards. I think they've abused their discretion and they've overused their discretion there, but they have significant discretion and leeway when it comes to the compensatory bucket of damages. When it comes to punitive damages, well, for a plaintiff to get an award of punitive damages, that means the jury has decided that the defendant's conduct was so egregious, so wrong, so willful, so blatant that it needs to be punished to disincentivize that type of behavior, right? That's what punitive damages are about. Punitive damages are about punishing egregious misconduct to make people think twice. People, and in this case, particularly companies, think twice before they conduct themselves that way, right? Make people think twice before they go around violating the heck out of everybody else's rights and just trampling on other people like they don't matter. That's the purpose of punitive damages. And so while courts are trigger happy when it comes to reducing compensatory damages awards, they are far less inclined to reduce punitive damages awards as long as those punitive awards line up with the State Farm cap. So we're talking like 9 or 10 to 1 ratio, okay? Which means if you get even $100,000 compensatory award, that opens the door for a really spectacular punitive damages award. And in these types of cases, in race discrimination cases, I think punitive damages are highly appropriate. They are absolutely appropriate, particularly in the more egregious, hateful, vitriolic, in-your-face instances of racism that I have seen come across my desk many times over the past several years. And, as I've said, I have seen very isolated cases involving discrimination or racism against white folks. It's not reverse racism. It's just racism, period. Racism is racism. But far and away, the vast majority of cases I see are against black folks. And in particular, the most hateful, vicious, ugly, egregious cases of racism that I see are, again, against black folks and sometimes against Hispanic people. But if you're dealing with a situation like this, it doesn't matter where it is, doesn't matter what context it's in, okay? It can be public accommodations, housing, retail, hotels, job, workplace, etc., education, whatever the arena is, okay? The time has come, for America to be against this shit, okay? And there are tools in the toolkit that you can use to attack and to combat racism. And I personally, I don't care who it's against, right? I don't care who it's against. If somebody has hatred or disdain or animus towards a person on account of their race or because of their race, that's not going to stand, okay? And if it's in a situation where, your rights have been violated, then feel free to reach out to the firm. We don't discriminate between, cases involving, racism, discrimination, 42 U.S.C. 1981. I don't discriminate, okay? I will take all comers. If I think it's a real case, I think it's a real case, and I'm on the job. Jonathan Pollard, have a great week.